titles in commerce. Featuring NTT, New Trust Technology. Presenting your host, Christian Walters.
Welcome, everyone, to Trust Ambassadors to Monday, January 25th, our second Trust Ambassador meeting. And we've been going over the document, A Practical Treatise on the Law of Trust by Frederick A. Lewin, the 1888 version. So maybe we'll just do a quick... anybody have any questions on what we did last week on this when we went over the first 2 pages, I believe? Did everybody start to get the terminology straightened around in their minds about all these fee-off and fee-off-ees and fee-offer and offments and all that?
Starting to get it. Hello?
Yes. Okay, I heard you.
Okay, I'm sorry.
So nobody has any comments or anything on what we went over last week or anything? Was it a little hard to digest? Let's put it that way.
I don't think so.
All we did was we just talked about the origins of the trust, but the subpoena. I found that very interesting on the subpoena. That was on page 1. We talked about the subpoena, where actually I kind of got a better understanding of when you summon somebody in by the original complaint, that the summons would be for the summonsing in of today of the fiction, the corporation. But then the subpoena would be for the real man. I never made that correlation. So when they come in and they summons you in with the original complaint, and when you answer the complaint, then that would be the surety or the pledge. And then once the real man showed up, they really wouldn't need a subpoena, except if they want a subpoena once they've identified who the real man was for, say, something else in the case. So by deduction, then, we would be doing the same thing in reverse. So when we come in with our counterclaims, we got to make sure we put a summonsing in their corporation. And then when they don't show up, or if they do show up, maybe later on in the hearing in the future, we would put in a subpoena, and we would use that subpoena, say, for an in-camera hearing, where you would summons in the trustee to compel him to answer upon oath the allegations of the Sedekey Trust.
Christian?
Yes, go ahead. Who's this?
It's JC. I'm looking at doing a subpoena duces tecum, which is for documents exclusively. And after reading this, it makes sense too. I can summons in an agency, bring in a particular agent who I'm working with or is working with me as an opposing party, and do 2 things: force them to bring in the documents that support their position, and then put in that same motion for the in-camera review. So when they don't show up with the documents and you're standing there with your SOI, it's kind of a double whammy.
Right.
Donna from Florida.
Hi, Donna. Yeah, go ahead.
Hey, just calling in, announcing myself. Is this Christian?
Yep, uh-huh.
Hey, how's it going?
All right, okay.
Good. All excited to be here.
So I was just going over a review for last week there, how we got into that, and asking everybody how they thought, any questions or comments.
Yeah, I got my Gilbert's Law summary in the mail on Saturday, so I'm really happy about that.
How about what we went over on this treatise last Monday?
That was really, really good. I mean, there were definitions of trust that I didn't even know about. So I was really thankful to get the, wow.
If you're not speaking, press *6 to mute out.
I thought that was really, really cool to have all the, and it helped immensely. I'm going to mute out now.
Okay, so I think the big part in the first page there was that when they talked about the origins of trust, where the bingo was at the end of that section, where it talked about that by the narrow policy of the common law. So they had been prevented from exercising the alienation and the settlement of their estates or their trust. So that's how they're looking at it. I think that's the reason why they've changed everything, really, because they think that the narrow policy of the common law was too restrictive. And to get their way so they could transfer property and do settlements of trust estates, then they had to come up with a different form. Now, I used to think that they got us to make a 90-degree turn off the path and form a parallel path with them, and they continued on. And I think I think that was wrong. I think they made a 90-degree turn, and we didn't follow, and we kept on going straight. So the wording was the definition wordings where they started changing the meanings of the words was one of the ways where they're tricking us to get us off the path. But then I thought, and just the opposite of that, it's like, okay, it's not that we take some common word that you and I know, and now I'm going to redefine it to mean something else. It's really that's one way, but there's another way. I can take the meaning of that same word, take that word off, and now put a different word on there, and now means the same thing. That's how they really derailed us. Because these funny words that we no longer use, although the definitions are the same, they put new words on these definitions, and in effect have hidden this. And I think that's what they did. They're the ones that did the 90-degree turn and formed a parallel path. But we kept on going on. We went on in the new definition meanings, and they're still using the old definitions, I think. So the narrow policy of the common law, then they changed that because it was preventing them from exercising the transfer or the settlements of the trust estates, or the trust. So the subpoena was used to bring in that trustee who was liable to be summoned in because of his self-interest. He was self-dealing, probably because there was nothing in writing that was spelling out a trust for the beneficiary. So the trustee decided to take advantage of that for himself and kept the property and probably said there was no trust. And then the subpoena came about to bring out the truth and put the property within the right hands of the legal owner who was supposed to be the beneficiary. And he was subpoenaed into chancery or into equity and compelled to answer upon the oath the allegations of the beneficiary. And then they say, no sooner was this protection excluded than half of the lands of the kingdom became vested in feoffees to uses or trustees, as trusts were called then. And thus the words of the old counselor, the parents of the trust were fraud and fear, and the court of conscience was the nurse or the nanny or the courts. And that ties right in with the definition of Black's Law 8th edition where it talks about the trustee, the cess duque trust, the constructive trust, under trust, where it says that the conscience of the court. Let me see if I can find that quick. Under constructive trust, a constructive trust is the formula or the remedy through which the conscience of equity finds expression. It says when property has been acquired in such circumstances that the holder of the legal title may not in good conscience retain the beneficial interest, equity converts him into a trustee. And it says it's sometimes said that when there are sufficient grounds for imposing a constructive trust, the court constructs a trust. The expression is, of course, absurd. The word constructive is derived from the verb construe and not from the verb construct. And the court construes the circumstances in the sense that it explains or interprets them. It does not construct them. And that was quoting out of Black's Law, but was making reference to Austin Wakeman Scott on the Law of Trust, 1987. So I think if we use in conjunction with this treatise on the Law of Trust by Lewin, if we use the one that is the 1919 version by Austin Wakeman Scott, where he has Scott on the Law of Trust, where it gives a lot of case cites, that can also be tied in with this, because that's giving it a 1919, which is close to this 1888 version, giving you more case cites and supports. So continuing on there, that was pretty much page, say, 1, where the bingo, I would say, was. But I found also in that subpoena where it's really talking about the pledge. That originally the only pledge, and the pledge would be the undertaking or the security to the duty, which would really be a bond, or a bond is my word, really. So that's what they were doing. They're giving their word, their pledge, or the due execution of the trust. was the faith and integrity of the trustee. So this was an extremely precarious security. In other words, that pledge, because it was only based on his word, I would imagine. So the pledge is the security interest in property or the title, and the interest being created by bailment or other deposit. So that would be the special deposit or trust deposit for the purpose of securing the debt or obligation. And again, my bond is my word or my pledge or a trust relationship. So page 2 then, the trust in simple or special. And we went down into the bingo that I say is so in order rightly to understand what was meant by the rather technical description that they gave above, we shall briefly consider the principles that were recognized by courts of equity, where these had the exclusive jurisdiction of trust. Even back then, they knew that a trust is only operating in a court of equity, and it still is today. And really, that's the power of the trust, really, is equity, because equity is going to force or compel the party to do what he was supposed to do, his duty, or to prevent him from doing something like breaching the trust. And that's exactly what we thought under Admiralty. We were coming in as a breach of contract, and we were sliding into equity, and equity was compelling you, and when you didn't do it, then you were in dishonor, and you got thrown into prison because of the dishonor, because you didn't do what equity said you were supposed to do. So here it was, really it was all about trust. It wasn't Admiralty at all. It was really trust. So first it says, with reference to the terra tenant, or the land tenant, or the fiafi, or the trustee to the trust, the uses, and secondly, with reference to the beneficial proprietor, or the cestui use, or the beneficiary of the trust. And then the confidence in the person, which con was living, and fidens, or fida, which is faith, the living by faith, and the person, or the trustee, which was the relationship with the person, for him to do the duty, the pledge, and with respect to the fiafi, or the trustee, to the uses of the trust, the confidence in the person and the privity of estate, or the knowledge of the trust, for want of the requisite of the personal confidence, it was ruled that a corporation, or a fiction, in other words, could not stand seized to a use, which was to be put into possession, or seized, put into possession to a trust. Or how was it said, could a corporation be capable of confidence, or, living by faith, when it didn't have a soul? Nor was it competent for the king to sustain the character of the trustee. But today, isn't the king no more than the state, or the United States? And why are they sustaining the character of, say, trustee? So I guess that's why they look at us as being the trustees, because they think they're the kings. But isn't it the other way around? But that's only in the private, not in the public. We're only kings in the private, but in the public, they look at it as they're the kings, unless you express the trust and came in chambers and proved them wrong by establishment of the proof of the trust. So it was thought inconsistent with the high prerogative that the king, he should be made responsible to his own subject for the due administration of the estate. So that's the reasoning why they look at you being the trustee. But that's in their backwards realm. And originally the subpoena lay against the trustee himself only, and could not have been sued against either his heirs or assigns, where the confidence was declared to be personal, and not to accompany the devolution or the transfer of rights of the property. But that was under the old view. Now, under the modern view, they want it to be alienable. So this old view ties exactly in with the Declaration of Independence and confirmation that all the rights were unalienable or non-transferable. But under the modern view, it's just the opposite. They want it to be transferable because that was the narrow common law view, and they wanted to take care of that. So for the confidence was declared to be personal and not to accompany the devolution or the transfer of the rights of the property, but the doctrine of the court in this respect was subsequently put on a more liberal footing, and it came to be held that both heir and assign could be liable to the execution of the use or the trust. An exception, however, was still made in favor of a purchaser for valuable consideration not affected by notice. So there it is, notice. giving notice is going to put an estoppel, because the purchaser couldn't, for valuable consideration, take it free and clear. He couldn't be a bona fide purchaser if he's had notice. And then they went into privity of estate, and privity of estate, which was a mutual or successive relationship to the same right in property as between grantor and grantee, or landlord and tenant. And if you have a warranty deed, and you looked up that warranty deed, I just so happen to have one, where it says that this indenture made on such and such a date between so-and-so and whose address is at such and such in the county of wherever state grantor, and then the other party, their name, whose post office lives such and such the state of wherever as grantee. So your warranty deed is nothing more than a privity of estate or a mutual or successive relationship to the same right and property between grantor and grantee, or the landlord and tenant. So we've never really left feudal times, because all this is a successive relationship of feudal times. And it says in this warranty deed, and it goes on about the description of the property, and that the witness has said that grantor, for and in consideration of the sum of $10 and other good and valuable consideration to said grantor in hand paid by said grantee, the receipt whereof is hereby acknowledged, has granted, bargained, and sold to the same grantee. Now, you think this is a sale? This is a trust. Sold to the said grantee and grantee's heirs and assigns forever the following described land situate, lying, and being in such and such a county, to wit, and then the legal description. And then the next paragraph continue on, it says, and said grantor does hereby fully warrant the title to be said land, and will defend the same against the lawful claims of all persons whomsoever. And grantor and grantee are used for singular or plural as the context requires. And witnesses whereof grantor has hereunder set grantor's hand and seal, day, the year first above written. And here all along we thought we were purchasing a property. And all you did was put it into trust, in a successive trust, a privity of estate. And privity really means knowledge. Knowledge of the estate. Estate means trust. So you had knowledge of the trust, because you signed the record, and the formation of the record was the proof of the intent and the purpose that you never knew or understood, but that's according to Sentier, which is not necessary in their public fiction realm, which is contrary to common law, where you have to have Sentier in the private in order to complete even a trust. So the privity of its trust, meaning the privity of estate or the knowledge of the estate or knowledge of the trust, may be best illustrated by the example: had the fee-off-ment been, or the conveyance been, made to A for the life to his own use or trust, with the remainder to B, or the interest to the use or the trust of C, and then A
Q&A mode is on. Participants may now unmute themselves.
So if you want to ask a question, you have to press *6. So, and then A had an oft or put in legal possession, D, in fee, that would be the interest in this case, though D had the land by the fee-off-ment, which then operated as a tortuous conveyance or a wrongful act, yet as he did not take the incidental estate or the trust in the land to which the use or the trust in favor of C was attached or transferred, he was not bound by C's equitable claim. And then we went over the bill, or the bill in equity, under section, I believe it's 130, I think it's section 456 in the Gilbert's book, bill in equity, and it gave the listings of in Black's Law, what I read in the bill, of the really nothing more than today's modern day counterclaim or the complaint, and continuing on by the same rule: neither tenant by the courtesy nor tenant in dower or tenant by legit, and that'd be the judgment, was liable to the execution of the use or the judgment of of the trust for their interest, where the new and original estates, and that was a big one, pretty good one there. The original estates were the first one, or the derivative estate, and that's probably where they get the derivatives of the trust from, or the securitization, bearing to each other the relation or the trust of a particular estate and the reversion. And the definition of reversion was the interest left after subtracting what the transferor had parted from what was the original estate, and could not have been said to have been impressed with the use of the trust continuing on. So the lord who was in by his cheat, I guess where do they get that? Well, in like Flint, or whatever, the new modern time there? And the definition of in meant under a, or based on the law, that is, to bring an action in contract. And that was the definition of in. So he was in by in this cheat, or he cheated. And he was really a deceiver, an abater, and an intruder. And a deceiver was a person who wrongfully derived another of the freehold possession of property, and an abater was a person who took tortuous and intrudes on the heir's freehold before the heir takes possession. So they were not amenable or legally answerable to the subpoena, or the first claim by title paramount to the creation of the uses, and the three last were seized or put in possession of the tortuous estate and held adversely to the fief to uses, or the trustee to the trust. So any questions so far? Anybody have anything? It'd be very interesting to study further this example that they give here. This A to B into C, and then A again, and then to D. Has everybody got that understanding there, what they're talking about there?
No. Could we go over those again and identify them? Try to identify them?
Yeah, it might be wise to do that.
Okay, I appreciate it. I want to get a clear picture here.
So had a conveyance been made to A, or the life to his own trust, so it would be from the settler to the, I suppose A would be the beneficiary, or this could be the trustee, really. A may be the trustee. For the life to his own uses, with remainder to B and fee to the use of C. So after A died, the remainder would go to B as the interest in the trust of C. So who is C now? They don't really spell out the terms here, though, too well. So to the use of C, and then A had an off D, put in a legal possession. So D had been put into a legal possession of the interest in the case, so he must have sued, and it was through D, had the land by the ennoffment, or the conveyance, which then operated as a tortuous conveyance or a wrongful conveyance.
Hey, Christian?
Yeah, go ahead.
A fee-offment, that's a gift, right?
A fee-offment is a conveyance of property.
Right, or a gift of property is what they got us to do, is to gift it to them. It said had a fee-offment, a conveyance of property, been made to A. So on the public side, A, they're, like you said earlier, they're seeing themselves as the king or the grantor, right?
Right.
So on the public side, A would be the estate or the trust. Would that be right? The estate, the trust, the Sedekey trust would be A?
It could be, because that conveyance had been made to A, yeah. So
that's what happened over on the public.
It's a little hard to understand this, because they don't set out who was...
Because you would make a gift to the trustee, would you?
Well, yeah, I would have to, because that's when the trust would form. So that's what I'm thinking. Either has to be, A has to be either the trustee or has to be the beneficiary.
Well, in the public realm, we're seen as the trustee, so I guess you're right, A would be the trustee.
I think it's more that A is the trustee, because that's the one you want to make the conveyance to.
Because then he's the trustee holding the property.
So that's for life to use or the trust.
So we get to use it as long as we use it in accordance to the trust, what they lay out.
Yeah, the way they construe it, but trouble is they're construing it because we never expressed it with any particular kind of oral indenture or any written indenture.
Okay, so A is a trustee with remainder to B.
Apparently he's using the trust for his own use until he dies, and then from when his death occurs, then that remaining portion goes to B, which is probably the beneficiary, in fee to use of C. So remainder to B and fee to use of C. So it may be that C is maybe the beneficiary, and B then gets the remainder.
C is the beneficiary, and B gets the remainder.
Yeah, I think C is the
And who's-
beneficiary, and the remainder after C is done probably goes to B, say.
And who is B?
That would say like B, C's kids.
Okay. Heirs.
Heirs, right. Then A, we're back to A again, say the trustee had an off D. So in other words, he was put in legal possession and fee, or the interest in the case, though D, let's say the D is the beneficiary, had the land by fee-offment or conveyance, which then operated as a tortuous wrongful conveyance. Now, that doesn't sound right either that way, really. If that was a wrongful act, conveyance of D, yet as he had not taken the identical trust or estate of land to which the use to trust in favor of C was attached. Yeah, go ahead.
Christian, this is JC. I have a comment.
Yeah, go ahead.
Thanks. In property law, think of property as a bundle of sticks, and you can only give away so much that you have, and sometimes you don't have all the bundle. If it's fee simple, you might be giving away the entire bundle. If you have what's called a life estate, you only have for the remainder of your life use of that property. And the way I read this, somebody has given to A, so a fee-offment, we don't know who, but a settler has made a fee-offment to A for life to his own use. So he has a life estate with remainder. So when A dies, remainder goes to B, and B is acting as a trustee in fee to the use of C.
Yeah, that makes better sense, yeah.
So then during the life estate, so A now has essentially probably legal and beneficial title to that, is equitable use for that, and maybe he's in acting as trustee. We don't know. Maybe not. Maybe just the beneficiary. But he comes in and represents to D that he has fee simple. And back in those days, when you didn't have the recorder and the Recording Act and such, there was there was a dearth of people who had life estates or a stick of the bundle that would then turn around and sell, just like a snake oil salesman, that land. And then that person would come up, claim title, and somebody else would swoop in and say, no, this is actually my land. And now you have a fight over the title because somebody who didn't own the entire fee simple transferred it for some kind of fee or monies.
Right.
So I think that's what's happening here. A is trying to transfer title that he doesn't have, and now they're trying to stop one of the parties from claiming the good title. I wouldn't get too wrapped up in this kind of
Under
example.
the privity of the state, and what you're talking about privity is knowledge. So it's the people who have knowledge.
Exactly. It's just illuminating that if D, for example, if D took the life estate from A, knowing that it was a life estate, and then tries to come back in, he'll be stopped from claiming that he has good title because he knew. He had noticed he got a life estate, and that's all he gets. So when A dies, D's title goes with it, and it reverts back to, and that's what the remainder is. So after a life estate, there was a remainder, which reverts to, by law, or a seat to either the state or to his heirs. And that's just property law, which is confusing.
Yeah, so S would be the settler who isn't mentioned here, or the grantor.
Right.
And then A would... Go ahead.
Could I ask, I'm sorry, Christian, could I ask you guys for book, chapter, and verse since I got in late with the Skype stuff?
Yeah, we're at the top of page 3. We're talking about the privity of estate, and the example we're going over there is the one that's in the trustee handbook, the Law and Trust by Lewin.
1888 book?
Yes, the 1888 one, right, on the top of page 3.
Okay, thank you. Any reason why we moved away from Skype, just out of curiosity?
No, we haven't really moved away from Skype, but I think Skype calls like on Tuesday. Or did we goof up? I forget. Did we use this number last week? I thought we did, or we didn't.
No, we did not.
Okay. Has anybody
Well, we
tried?
used whatever number was on your.
Has
No,
anybody,
we used whatever number was on your call line.
Yeah, I mean, what you sent me today was correct, but it was not the same information as last week, and I'm wondering why we moved away from Skype, because I know there was somebody that was in England that was on the call, and who knows where else. So Skype being free for the free conferencing, I was just kind of curious why we moved away from that.
Yeah, I was thinking Pete had gotten in on the chat room, and he was able to hear the call line from the chat room, and well, I might be
So on that for shared chat room, it's you don't hear any, you don't hear anything. You can text, but you don't hear any audio.
There's no audio in the Share Plus.
Not that I'm aware of. I mean, unless somebody wants to clue me in on that.
Okay, then that's probably my mistake. That we probably should be on the other line then. But anyway.
Yeah, I just was curious. I'm sorry. I didn't get sidetracked. Okay, top of page 3, 1888. Thanks for everybody's indulgence in my question, asking silly questions.
Yeah, I'm a little confused on all these different numbers we're trying to sort out and get the right ones that seem to work the best. And yeah, you may be right that we should have been on the other line for this call and just using the meeting room. So my confusion.
I don't know. Yeah, I don't know if it's right or wrong. I was just kind of curious why it changed. Okay, thanks, Christian. We all appreciate what you're doing, and so.
My question is, has anybody tried to Skype in using this number that we're on right now? Will that work like that other number?
No, it did not work. What I did is
JC Skype into this number is fine.
The old information for Skype, I clicked on the free conferencing because you need to add that into your contacts.
Right.
So I hit the free conferencing, and then I used the old PIN 91730. 917030. We could hear you guys a little bit in the background, but we never really were part of the conference. So we had to get off and use our landlines to dial this number, the 213 number.
JC Skyped into this and it's just fine, by the way.
Oh, you did Skype in here on this number?
I'm Skype, yeah, along with the whole rest of the group.
Well, that's great then. Maybe we can just use this number that comes in with. I wasn't quite sure whether or not that would work for this call number, and that's why I had.
Okay, I got a question for the people that did Skype in. It's costing you time, right? Because it's not.
Well, no, not a regular Skype call, because that freeconference.com. If you could Skype right in without the cost.
Right, so that's what I'm getting at is the other number was free to everyone, and this one I think these people are having to use their Skype account minutes cash to listen to this call. Is that correct?
Well, I hadn't sorted that out yet. I knew that the other number that we used for the Tuesday night call, I know for sure that that one was particularly set for Skype because it says it Skypes. This call...
There was a gentleman that said Jason and a bunch of people Skyped on, so I was just kind of directing my question maybe to him that is he having to pay to right now to listen to this number, or was it free to him?
Yeah, that'd be interesting to find that out.
This is JC. I don't think I could be paying for it, but I mean, what is it? A penny and a half a minute? I don't really know. I'm not paying.
You got to do a regular call, and then you got to do something totally different. You don't put your Skype into contacts at all.
No, I did. I created a contact. I entitled it Trust Ambassador line, and I dialed it, and it connected through just like any other Skype call.
Oh, did it? Okay.
Yeah. So I mean, if it's free to landlines, which I thought it was.
Yeah,
then,
I didn't know.
It should be
I thought it had like that 712 number. That was specially set up for Skype. At least they tout it to be with Skype, so that has to work with Skype. I was wondering whether this number we're on now, whether you could do the same thing with it. I never tried it yet. But you say that's how you dialed in.
Correct.
Well, if that's the case, maybe we'll just use this number that comes with Share Plus then. I'll have to get a hold of Pete and see whether or not he can get in. Oh, he's on the chat line.
What pin did you guys use to get into Skype, or to get on the call from Skype?
The one that was in the email, 988-6156.
See, I tried that and I couldn't get in.
It took me 2 or 3 times to get in, but it took it eventually.
Really? Okay. By the way, the domestic calls on Skype shouldn't cost money. I think that was someone's question. So
apparently, you can just do like Skype chat, and then the only thing you have to do is punch in the code, right? Well,
Christian, I have a comment too on that paragraph that we're talking about, trying to get back to the trust law. When you talk about the courtesy and the dower, those two things, and I look at the tenant by illegit too, nor tenant by illegit. Those three things, especially the courtesy and dower, those were basically designed in trust law back in the olden days to allow a husband to pass to a wife or a wife to pass to a husband the remainder of their estate, so that it wouldn't accede to the state, and it allowed. Generally, it's designed for the wife so that she wouldn't be left homeless after the husband died in a fit of combat and war across the land.
Right.
So that whole thing is when they talk about the original estate, they were talking about even with the execution of the use, this transfer, that original estate, that courtesy or dower, is not going to be impacted by that because they don't want to dislocate the widow or widower for that purpose. So I just wanted to bring that out.
Because they had the dower was the wife's right upon death of the husband to a life estate of 1/3 of the land that he owned in fee.
Right.
And it was only the courtesy was if they had a child that was born alive. So I guess that was in protection of the child, which was going to be the new owner and the heir. That kind of ties in with, if your strawman is dead and we never have an heir, then they don't have to worry about the child, so they don't pass on the title and worry about the title and dower and courtesy then. But let's go back up to where we're there with that. And, so we have S, say, is the settlor or the grantor. And then, so who would A be then?
I think A is the first beneficiary that they're referencing. So there's a fee offset made to A. We don't know who the grantor or settler is, but we know that A has the life estate, and that's where it begins.
So that would be beneficiary instead of trustee?
It maybe the settler remains the trustee of that. I don't think we know in this point. What we do know is that A has a life estate, and I think A makes an effort to transfer the property through a fraudulent conveyance to D. That's what happens down the line. So A gets a life estate, and then when A dies, that remainder goes to B as a trustee, as I read it, for the use of C. So C is basically the remainder beneficiary of A's life estate. And in that process of A having this equitable ownership for a life estate, A transfers to D, and in this case, though D had the land by the transfer, which operated as a tortious conveyance, because A could never transfer it to D. He only had a life estate. And when they talk about the identical estate in the land to which the use/trust in favor of C was attached, what that means is the identical estate, you can only transfer as many sticks in that bundle as you have. A has only one of a couple sticks, meaning the life estate, and that's it. Can't transfer any more.
Sounds like
so when they transfer...
Sounds like A would be more like a trustee then.
Or just a snake oil salesman who tried to rip off the remainder beneficiary by selling his current non-fee simple estate and taking the cash and going to on vacation.
Yeah, that could be.
And that happened a lot back in it because there was no way to check legal title really back then. There was no recorders. So that all these things are designed to help protect the remainderman, which is the follow-on beneficiary for these life estates, and the bona fide purchaser, which again goes back to notice, which you're talking about. Notice removes any claim and stops anybody from stating that they're a bona fide purchaser, because BFP takes for fee and without notice.
So we have C in here. Let's see. C did not take the identical trust or the estate in land to which the use or the trust in favor of C was attached or transferred. So possibly the beneficiary might have been C then. C was supposed to get the beneficiary. And A would be the trustee or the party who took it in fraud.
Well, A is still the beneficiary because A still has a life estate. So the fee is made to A for life to his own use. And then when A dies, the remainder goes to B. So B is, maybe, let's look at S. So S makes a transfer to A for a life estate. That's one of the several sticks of the bundle. And then S has a favorite son. And so whenever A dies, maybe A is S's brother, older brother,
Older
knows
brother,
he's
yeah.
going to die first,
Mm-hmm.
and then the remainder is going to go to S's son. And A is trying to rip off the son by selling it to D, and then when he gets the cash, he's going to transfer it over to his girlfriend. And if D knew any of that, he's going to be stopped from that. He'll lose the money, he'll lose title, and he'll walk away a loser.
Okay, still some question about C. Who's C again?
Well, okay, yeah. So in that analogy, it looks like maybe B might be holding as trustee the legal title to it. So when S transfers to A this life estate for the use, and A dies, S may be near death as well, and may not be able to administer the estate. So when that happens, then it looks like maybe the remainder is going to revert to B for maybe whatever bundles of sticks that A had. That doesn't make sense, though, because to me it appears that B is a trustee for the use of C. So C is, again, a follow-on beneficiary. So somehow B is acting as a custodian again for C.
There might be multiple beneficiaries, like you say. Maybe A is a beneficiary for the life, and then B is the beneficiary afterwards, and C could be the trustee. Or C might be the remainder. No, that wouldn't be right.
I have to look at this word. I'm not sure if this is the case, but it says in fee to the use of C. Fee might be the modern or the olden use of fee simple. And if it's in fee simple, then what that tells me is that S transfers one of the several sticks as a life estate to A, and then the remainder. So when A dies, then the remainder of that life estate and all the rest of it that is transferred to B.
Although he doesn't have possession.
Right, because it's for the use of C.
Right.
So it looks like everything is transferred after the life estate in fee simple to B. Now B is acting as a trustee of legal and equitable title for the use of C. So it's almost like the equitable title skips through the palms of B for a second and then is transferred immediately to C for the use.
So actually B then
So
would have
still
a purpose. He's holding the remainder, plus he's going to be trustee also.
Right, that's how I read that. He ends up as trustee holding legal title. C ultimately ends up as the ultimate beneficiary after the life estate. But in the meantime, A transfers to D.
And that was done in
leaving B with... So B, or actually, so B probably as a trustee would then would probably litigate against D on behalf of C's interest. Or C as a beneficiary, the intended beneficiary, could claim that A had wronged.
Instead of passing it to the remainder man, he passed it to D in fraud instead of B.
Right.
Well, that still kind of leaves C out there hanging, no? C.
Well, C is the ultimate beneficiary. So as soon as A dies, C is supposed to have use of that.
So C got cut out altogether. He can get nothing.
Yeah. So C's gonna have to bring the action and enforce his claim against D. So he's gonna have to sue D and A if A is still alive and C knows about it.
So C would be the beneficiary then to bring the claim.
Correct.
The one it was ultimately supposed to be then. All right, so C is beneficiary also, but that's after A, who's also a co-beneficiary, has life estate until he dies. B is supposed to get the remainder, but the life estate is supposed to go to C, or the bulk of the property.
Right.
So C didn't get the property. We don't know if B, the remainder man, got anything or not, but A transferred it to D under fraud, which should have been transferred to C as the beneficiary of the life estate.
So B acting as trustee for C, the beneficiary, both B and C are going to bring an action against A and D, both to quiet title and to sue A for fraudulent conveyance, and D for unjust enrichment. All those causes of action we talked about before.
Mm-hmm.
So there's going to be multiple causes of action, multiple defendants, and I don't know if the beneficiary would bring the claim or the trustee would bring it on behalf of the beneficiary.
Yeah, I've read in Gilbert that the beneficiary must bring in behalf of the trustee. He must allow the trustee to bring the claim first. And if the trustee won't bring the claim, then he can bring the claim as beneficiary. But he has to write the
right. So
behalf of the trustee. So he has to go through the trustee.
Mm-hmm.
So any breach of trust would probably by the beneficiary committed by the trustee still has to come through on behalf of the trustee. Probably the court would look at it that the trustee would be fired or taken off the duty because there's a claim against him. And since he won't bring a claim against himself, some other trustee would have to be appointed to complete the duties. But the beneficiary is going to have to make a claim through the trustee on behalf of the trustee. I don't think he can make a claim in his own name.
Right, and this example is a little bit different without getting into the weeds of this one. I think this illuminates a couple things, but I think really the beneficiary and the trustee will work together on this because the trustee is not in breach of this. The trustee was cheated out of essentially the legal title and the ability to operate this land on behalf of C because A was a thief.
Right, A and
D may have had notice.
Yeah, A and D
may have been in cahoots. They may have been. So.
B and C were on the good guys.
Right.
Yeah, that makes better sense that way now. That kind of ties in with everything they've been doing so far. That most of this trust, most of the property got put into trust once they came up with trust, and they were being fraudulently transferring property all over the place because there were no records kept to find out who was exactly the owners, and the only way to get any remedy was to sue somebody. And then since the Court of Equity didn't have any powers at that time until the subpoena came about, the subpoena in the trustee, and then that ties into the first part on page 1 where it says the trustee is the debtor by interposition. So under presumption, the trustee is assumed to be guilty as the debtor because they're going to assume that he wrongfully conveyed property right off the bat under equity. So to bring the property under the rightful owner's hands, then the action was brought forth by the beneficiary on behalf of the trustee. So I wonder how this other stuff is, anything really, how that ties in with the courtesy and the dower, because they talk about by the same rule, neither the tenant by courtesy nor dower, nor tenant by legit judgment, was liable to the execution of the uses where their interests were new and original. I guess at that time they didn't, because it was non-transferable rights at that time, I suppose. So the original states and could not be said to have been impressed with the use or the trusts.
I almost wonder if on that original, the fee offment, when we go back up to the first line, we just chose S as a settler for that fee offment made to A. I wonder if that means that, okay, well, A can have a life estate, but you're not going to take the third of the estate, which is the original estate, because that is superior to the life estate. So the third, the tenant and dower, that third estate that the widow gets is the original estate that is not part of the life estate. That's how I think I interpret that.
Yeah,
again, as an effort to protect that mother and child.
Yeah, it must be tying it in there somehow too, because it's all in the same paragraph.
Which probably means that that portion of the title is quieted as it relates to all the rest, which is now has been tortiously conveyed. So there's a title issue. Well, why do you want to drag the mother and child through that? Because they have the original estate, so they're not even part of that. That was never under the original issue.
Yeah, has anybody looked up the word impressed? Okay, there's impressment, court's imposition of a constructive trust on equitable grounds. Okay. Or the act of forcibly taking something for public service. That doesn't quite fit. And then the archaic one says the method by which armed forces were formally expanded when so-called press gangs seized men off the street and forced them to join the Army or the Navy. Black's Law 8 seems more like the number 2 definition. The court's imposition of a constructive trust on equitable grounds. See constructive trust under trust. So the original states and could not be said to have been impressed with the use or impressed of the trusts or the imposition of the constructive trust or the, so it could not have been said to have been impressed with the use of the trust. Original states. Okay, so that must be talking about the original states being the 1/3, like you said there, JC, on the dower. So the 1/3 original was not to be put into the cesticate or the constructive trust or the cesticate or usus trust. So the lord who was in by escheat, in other words, that was the action, because in was the to bring an action in contract. So the Lord who was in by escheat, and the definition of escheat was a long one. So escheat, the reversion of land ownership back to the Lord when the immediate tenant dies without heirs, and to the reversion of property, especially real property, to the state upon the death of an owner who has neither a will nor legal heirs. And 3, property that has so reverted. And now they give an escheat. It says all escheats under the English law are declared to be strictly feudal, and to import the extinction of tenure. The rule was that if the lands were held in trust in the Cestui trust without heirs, the land did not escheat to the crown, but the trustee. Being an esse, the legal season of the land, or for the land, took the land discharged of the trust and bound as owner of the feudal services. But as the feudal tenure do not exist in this country, there are no private persons who succeed to inheritance by escheat, and the state steps in the place of the feudal lord by virtue of its sovereignty and as the original and the ultimate proprietor of the lands within its jurisdiction. So it sounds like what they're doing today, but it really hasn't left feudal times at all. So the Lord who was in by escheat, and he was a deceiver, an abater, and an intruder. So he stepped in and took it before the heirs took possession. And the last 3 were seized of the tortuous estate. So the last 3 were put in possession of the tortuous estate and held adversely to the trustee to uses or trust.
So my take on that is that if the estate is moved by escheat to the Lord before the trust or in advance of this the fiathment by the settler, that is going to be a superior claim to all the other people, the life estate, or to the fraudulent conveyance, tortious conveyance, or anybody else. So A, B, and D, all who had those 3, all who had some type of claim to title, all of those are holding adversely, meaning
to the Lord.
They don't really have a true right to the title.
Right to the Lord.
Exactly, adverse to the Lord, to the fiat to uses. So the settler, whoever tried to transfer that, it was already escheated to the Lord, and they have no title nor any claim.
Well, it sounds like the Lord stepped in to quench it all and then say, hey, I got the whole thing, what's the use?
I think that demonstrates that the Lord and the state, if they take by escheat, it quashes any claim. It's superior to all others, so you're out of luck. Everyone's out of luck, which is kind of like we have today.
Yeah, right.
That's why a sheriff shows up and at gunpoint takes your property because you quit paying something. They make a claim, and it's going back to its rightful owner.
Now that's going on the presumption that they are the Lord, because nobody expressed a trust that would make them the Lord. But how about if you expressed a trust, who would the Lord be then? I would say that would be us then. It should be the other way around. We should be in the Lord position or the grantor position, which ties back in with the Declaration of Independence again, that we were given all the rights. So it comes back down to claiming and proving the trust. And can the so-called fiction Lord of the state, can they actually make a claim of trust against a real man whose tie was the Declaration of Independence or the Bible? Just like they were saying, the earlier paragraph, the next previous section there, we're talking about the corporations. Confidence in the person there on page 2. Where for want of requisite of personal confidence, it was ruled that a corporation, or let's say the state, because the state's nothing more than a corporation today, could not stand seized to a use. Well, how could a corporation be capable of confidence when it didn't have a soul? So in regards to the Lord in those days, he was real and alive. He was a real person. But today, the corporation is nothing more than a corporation of the state, and they can't be the Lord because they're not alive. Would anybody agree with that? Or disagree with that?
Absolutely.
So it says, nor was it competent for the king to sustain or maintain the character of trustee, for his thought it was inconsistent with the high prerogative that he should be made responsible for his own subject for the due administration of the estate. That right there could be a defense. That could be an adverse claim right there. How can you claiming to be king which is going to be inconsistent with your responsibilities over your subjects for the due administration of the estate.
That must be why when they a U.S. citizen is defined as being a subject.
Yeah, in the fiction realm, right? With no rights.
Right, I think it's just like you said, it's the mirror image. In the private, we're the king, they're the subjects. In the public, they're the king, we're the subjects.
So if we would claim trust, I wonder if there's any trust laws that knocks them out of the box, so to speak, as corporation fictions under trust law and equity, where they can't be the kings and take by his cheat, because they can't make the subject responsible for the administration of the estate. Anything come to mind as case precedents on that, JC or Harold?
I don't have any case precedents on that I can offer up.
It stands to reason that that he couldn't be made responsible for his own subject for the due administration of the trust. If it seems to be something in the back of my mind, but I can't put my finger on it. Pull it up. Seems to me that that could be used possibly as a defense against his cheat, saying that the fiction king can act as a sovereign and take in his cheat as being sovereign. And then
I think that's the kind of thing. If you were to make that claim, that's something that you'd absolutely have to do in private, because there's no way in public they would come out and give you that acknowledgement. So
right
now you'll be arguing that claim, and to do that, you have to bring in some type of. The courts listen to case law, or some superior type of law. So we're going to be arguing in chambers this concept of feudal land ownership, and whether you can get in a chamber's in-camera hearing to even pay attention to some of those matters, it's possible. But I think that's going to be a hard battle to go uphill on. But you can always make a claim. That's a great part about it. State a claim and let them rebut it. Let them demonstrate why the king, in both public and private, has the right to his cheat in this matter, and why you, making a claim with your SOI coming in as the beneficiary of this, why your claim is not superior. So you might be able to do that in some type of a negative environment style, again, putting them under contract so that your record is superior in the private.
Yeah, I think there's more there than what meets the eye. I think if we dug in that and maybe checked in, it might be able to pull something out of that a little better. Let's say, okay, equity is going to be just for compelling somebody to do something or to compel them not to do something that's wrong. So if it was proved that the state was in the wrong and they were going to cheat, then the court of equity could have stopped them from that performance. If it was going to be proved that they were in breach of trust, so they could be prevented or stopped from taking the property in this cheat. So they say, nor was it competent. So, competency for the character of the trustee. So actually to act in the wrong position would be a competency issue in violation of the character of the trustee for him to maintain that view of his cheat, because it's really inconsistent. So it's competence, character of the trustee, and inconsistent because he can't do the administration of the estate over his own subjects. That's,
Hey, Christian.
Self-dealing. Go ahead, Rhonda.
Well, now it makes sense why they made us trustee has to have you have to have confidence in the trustee, right?
Right.
And confidence is what? Living by faith.
Right.
Well, no wonder they had to make us the trustee over on the fiction side, because there's nobody. The fake king corporation is not living.
Correct.
So how can they? If you're not living, you can't be a trustee because you're not living.
Right. So yeah, that's why they want to make us the trustees, because they can't stand seized to the uses. So they can't be
you have no
possession
confidence in them.
They can't be put in possession. That could be the whole key right there. So if there was no trustee, because we didn't claim we were trustee, they can't be trustee, and they can't even be king, can't even be lord, then who does it revert back to?
Well, wait a second. Did they not appoint a trustee of the bankruptcy already and all the assets? Is he not already appointed?
Yeah, but is he living as did he separate himself from the United States and have that dual position where he can be living and
Maybe that's why they.
function livingly and dead.
Maybe that's why they have to do that. So he's not a U.S. citizen
Because
a real man.
exactly, then he's not a corporation. He's holding as a real man as a trustee.
Yeah, there you go. Yeah.
That's an aha moment, right
Yeah, yeah, that is. Now we understand why they have to have expatriation and be outside the United States to hold the bankruptcy. Well, then that comes back down to who is the real trustee. Then there has to be a real man. Then.
Well, on the public side, then he's the Secretary of the Treasury's one trustee, and then could we possibly make ourselves co-trustees?
And that's where I was going next. Or just a declaration of co-trustee, or maybe just trustee, period. And that would tie in with the termination of the trust, and which would be a form of expatriation by your action. Because now you're not acting in the fiction realm any longer, and you're given a revocation of your allegiance. Very interesting stuff in the first 2 pages.
Would we want to do that just by notice?
Probably by declaration.
Okay. Now, a declaration, I thought, was what a grantor made when they was going to transfer a title that they was already going to be holding. It wasn't really going to nobody else. They was just declaring to the other parties that they're in possession of that title.
Okay, there's a declaration of formation of a trust, but a general declaration is made by a real live man.
Okay.
A man or a woman is the only one who can make a declaration. And that doesn't have to be really notarized. If you're a corporation, you got to swear, or under penalty of perjury. But yeah, the fiction would explain why the real man, as the bankruptcy trustee, would have to be the real man, expatriating out of the United States corporation, be able to hold the property as trustee. Because the fictions wouldn't be competent, can't sustain the character of trustee. And even a fiction king, same thing. Inconsistent, shouldn't be made responsible over the subjects in the administration of the estate. So the trustee would be accessible by subpoena. So the original of the subpoena lay against the trustee himself only and could not have been sued against either his heirs or assigns. So the confidence was declared to be personal and not to accompany the transfer of the property. But the doctrine of the court now, with respect, was subsequently put on a more liberal footing. It came to be held that both the heir and the assign could be liable to the execution of the trust. There's an exception, however, was still made in favor of the purchaser for valuable consideration not affected by notice. What were you saying again about the notice again, Rhonda? Rhonda, you still there about notice?
Yeah. He was talking about. He was talking about expatriation and declaring ourselves not to be a United States citizen and all that. That's what I was saying. Could that be done by notice? And you said declaration. He was talking about like how the Secretary of the Treasury has expatriated himself so he could hold those 2 positions.
Right.
He could act as a living man and as a fiction. So however they do it would probably be the way.
They say an exception, however, was still made in favor of a purchaser for valuable consideration not affected by notice under A. Has anybody looked up the uses of and trust under B? Where was the BAC, the AB uses and trust B?
Where are you at?
The footnote A.
Oh, footnote A.
Has anybody looked up the uses and trust?
I looked up uses.
And then it says up in the body again, it says an exception. It's got a star. But I don't see any star in the footnote. Oh, there it is, number 3 to the left. Is that what that means?
To me, that just represents another effort for all of the law to protect a bona fide purchaser. They want to make sure that commerce is protected, and that if a person purchases for value without notice, that BFP, bona fide purchaser, maintains that title.
Yeah, they want.
Otherwise, commerce shuts down. Kings or kingdoms crumble.
Yep.
Right. Money stops flowing. I just had a thought about this too. When you're talking about defenses, so if the corporation cannot be trustee, then again, that's one more defense. We want to bring that into chambers. But if they're claiming that you're a trustee, or even if you declare that you're a trustee by signing a 1040, you could nunc-pro-tunc that and say, you know what, I woke up yesterday, I realized I was not trustee, and And by the way, I'm not the corporation, I'm the living man. You can do all that in chambers. And one of the defenses you'll bring in is, because I'm not a corporation, well, I guess you can be a trustee, but they're coming after the trustee, the U.S. corporation, your straw man, as a trustee.
Right. And the corporation,
So you say that straw man. That straw man is not the trustee.
can't be one.
And I never signed up for that.
No, the straw man's not, but you are as a surety for him.
Yeah, showing up as a real man. Yeah.
Well, that's why you just show up on your paperwork as a grantor or beneficiary or some other party.
Yeah, I think you're right. You just
You're always qualifying your signature.
set the record straight. Yeah, you're the only one who can. Because are you showing up as a real man or are you showing up as the trustee? You can't show up.
Paperwork says grantor. I'm showing up.
You can only show up as a real man and be trustee.
Right. Right. That's why when they get the real man in there as trustee who didn't pay the bill, he goes to jail.
Correct. He's in breach of equity. Because the only thing that the trustee is assumed to be is guilty because he didn't make the payment.
So like he was talking, let's cut the tree down at the stump at the base instead of picking the leaves off. So should our priority be to set that IMF record straight?
Yeah, because that's the one everything else has got to match up with. And we're really in control of correcting it. And since we don't correct it, it's been construed. In fact, we've even voluntarily set ourselves up as trustees. So now the question is, how can we be duped into serving for the trustee being a real man?
Because only a real man can be a trustee.
But like you said, just set the record straight that the real man is not the trustee.
In the meantime, do you think it would be better, since there is a trustee for the fiction, the Secretary of the Treasury, our co-trustee, would it be better just to send the res property to him, to let him do the conversion and make the settlement? Because he's the co-trustee. We don't have the ability to make the conversion. He does. Should we forward the res property to him? And then if he don't perform on his duties, we can show that we moved the property to him to do so, to make the settlement?
Yeah, quite possibly, yeah.
Which arrest property are you talking about, Rhonda? A money order, Declaration of Independence?
Well, I'm talking about right now until we get all that straight. Any other trust situation, like Christian says, we got thousands of them going out here, whether it be a court case or whatever. That's all. Those are all sub-trust, right, Christian?
Right.
And they're sending the trustee a bill for that sub-trust. So why don't we just? That's the bill is the res property. They're wanting payment. The beneficiaries are wanting payment. So go ahead and assign that to the co-trustee and move it to him to let him do the conversion. He's the big honcho. He's the main living trustee for the corporation. We're just sub-trustees.
This conference has 17 other callers present.
Have a private agreement stating that you're not a co-trustee, you never intended to be, and if you were, you're giving back all of that delegation of authority or misappropriation on your part accidentally to the intended trustee.
Yeah, if we had in 1933 given all the property into trust, there had to be a trustee that knew what was going on.
It had to be somebody acting as a living man.
Right. The fact that they expatriated, that was really proof that it had to be a real live man, so. I think we've opened up some cans of worms here.
It's time to go fishing.
Christian, this is JC. I'm going to have to hop off and mute myself out for the rest of the call, so I'll be here, but I'm not going to be able to speak. So thanks for tonight, and I'll let you keep going for the next 20 minutes.
Okay, all right.
You know, like we was talking on Saturday night, we was talking about the trustee and the judge and them, declining to be trustee. And after that call, I thought, well, that's right. It's us, the trustee, and I was talking about, well, once you've accepted, part of the trust as trustee, then you got to take it all. And that really applies to us, not the judge, because we're the ones that's the trustee. So it might be better, rather than to move it to trying to make the judge a trustee on something he's never accepted before as being trustee on, is to go ahead and move it back to the Secretary of the Treasury, because he has accepted being trustee on the trust.
Well, then the way to get him into court would be to subpoena him then in chamber.
Now, if we move the property,
I'm aware of
the property back.
I'm aware of some types of actions against the Secretary of Treasury where he wrote back and said, that he was really outside the realm. But if the United States fictions had some kind of action against him, he was probably right. He was outside of the realm. But if he's a real man and a real man hauls him into a court of equity, he might not have any immunity because he's on an equal level as trustee to subpoena him in the court of equity.
Right, and we got the record to prove that we moved the property to him.
Correct. Yeah.
He's really the only one that can take care of it. He's the trustee for the Aesthetic Trust, for the U.S. corporation. And he won't be able to decline it like a judge will, because he's already accepted. He's already accepted being trustee.
Might be better to do the Treasury directive, since he's in the Treasury anyway, 25-06, and call that DIB hearing, rather than try to haul him into court, say, since it was a fiction court.
Do we have anybody that's ever done a DIB hearing?
Yeah, we've done DIB hearings before, but trouble is you never know by the Treasury because they're private. They don't inform you what the outcome was or whether there was such and such a date, because you don't really show up. But you're just calling a DIB hearing, formal notification that you're setting a hearing, and then they take it from there.
So you call a DIB hearing, they take it from there and never get back with you?
Well, it could be that we've never asked them properly to, give us receipts back, or maybe they can't give us receipts back because we didn't do enough from a standing point, under trust, that we had any authority to ask for a receipt, and then we couldn't get a receipt back, so they never gave us receipts back. In fact,
they was construing. We allowed them to construe that we was coming at them from the public side.
Yeah, because everything we've really done, we haven't done under trust. We've done just basically under debt or creditor, and I don't think we have any standing to do anything. So we called the DIB hearings, and nothing was probably done. They didn't even generate any receipts because they probably didn't do a set-off or anything. Or if they did do a
so was those DIB hearings called on the, what do you say, that Treasury Form 2506 or what?
Yeah, under the Treasury Directive, 25-06.
Would that be a public document?
Yeah, you can pull that up on the internet. It's a directive from the Treasury.
But my question is that a public Treasury document or a private Treasury document?
Yeah.
Remember how we talked about using their documents?
Yeah, this
drags you back into the public side.
Yeah, I haven't looked at it to compare that, whether it has, like, on their forms under the public debt side, yeah.
Maybe we wouldn't want to use, if it's a public document, maybe we wouldn't want to use it. We would do our substitute document, the private side, to, like you said, make declarations, orders, and commands.
Yeah, after we've established our standing under trust as the grantors. That's the first step, or else you don't have any standing to make a claim to order or direct. So we didn't have any standing to order them to do a set-off. We didn't have any standing to demand for a receipt back. If we called a directive hearing, they found out in the records shortly after that probably, hey, it wasn't done under trust. They don't have standing. We don't have to listen to anything that they say. But here, throw them a bone, keep them off track.
But once we express the Declaration of Independence as our own, then when we come over to the Treasury side, depending on if that's a public document or not, that 2506, it is, at that point, we may not want to use that 2506, but then make our own declarations, orders, and commands to the Treasury.
Just the 25-06 is just an ability to, you just write a letter to the Treasury, and you're claiming under that 25-06 directive that you're calling a DIB hearing, and this is what's wrong, and I want you guys to straighten it out. According to the U.S. Attorney's Manual 6-4.010, these records are inconsistent, and here, please correct all your records, and all the subsequent computer tracking and all the other agencies got to comport to that. And if I put that in as my declaration of independence, that I'm the grantor in the whole thing, establish my standing, now I got the right to come in and ask for the set-offs and the discharges, order the discharges and order the set-offs on the public and private side, order the settlements, order the closures, order the moving of the title, order the conversion of the funds.
The grantor has arrived.
What was it we were going over the other night there about order the merger of the titles, the conversion of the property, and merge the titles in the straw man, and the remainder of the funds on the public or the private side would then, move that into a new trust, then form a new LLC on the public side, and start generating some interest on the trades and deposit the interest in the new LLC. And it's all foreign source.
Would we have to establish a new LLC, or is that mirror image basically an LLC?
Well, I think you'd have to establish an LLC at least, or maybe a trust from the LLC, because the straw man is terminated, so that account's dead. It's gone.
Okay.
Once we move all the total debt titles into the straw man and we merge a corresponding assets out of the private side, then the straw man will terminate. There's no more debt. There's no more purpose for the trust. So then it's going to have to be the remainder, which is going to be really all the assets still held in trust for the private, the real man. There's really only 1 penny of lawful money will discharge all the debts.
Yeah, 1 real penny's worth a kabillion fiction.
Yes, and the order to merge the titles, I was likening that to a bill of exchange. So bill of exchange is really under debtor-creditor, but likening that to the bill of exchange is the merger of titles under that section, what was it, Gilbert's book, what number was? 59? Yeah, section 159, merger of titles, on page 41 of Gilbert's.
Page 41?
Yeah, the merger of title under section 159. I liken that to the bill of exchange, and the bill of exchange under debtor-creditor. So what we do like that, like the except for value, is the merger of the title, which is the bill of exchange. So a bill of exchange is we're just exchanging one bill for another. So we're exchanging the debt on the one side for the asset on the other. And when you do that and they touch, then they discharge on the public and set off on the private. So the order to merge is likened to the bill of exchange.
Hey, Christian, it's Lou.
Yeah, go ahead.
I got a question. You're talking about discharging the debts. Now, when we're doing this, how would you be able to keep the accounts open? Like, say, your electric bill or your gas bill and things of that nature that you want to keep the account open in good standing. How would this apply to that as well?
I'm afraid you're probably not going to be able to keep the accounts open, because once the straw man terminates, he's gone. That account doesn't exist anymore.
I got you. So that's why you were saying basically establish that LLC.
Right.
And recontract all over again under that LLC.
Under the LLC, right. And now the LLC funds is generated from interest drawn against the foreign source, which is, held in the private. Because as soon as the people at the DTC going to release all these debt titles, all these treasuries, and maybe all these gold certificates they got, they're still certificates and they're still fiction money. And what they're going to do is they're going to take the temptation of receiving all this, say, $35 billion plus in assets, liabilities, which is debt really. And they're going to be tempted to go out there and spend that and use it as money again. And as soon as they do that, they're going to fall into the trap. They're going to fall into the benefit trap. They're going to put in recirculation the debt currency that they've been trying to get away from. They're going to put themselves back under debt again right off the bat. In fact, they never got out. So what we need to do is we need to merge that debt title in that straw man and set off an equivalent in assets to equal it and merge that title in that straw man. When we do that, then that straw man account, that terminates it. And the remainder on the private side, we're going to put that into a new trust, and the remainder would probably be 1 penny less than what it is, because 1 penny is going to discharge the whole shebang on the liability public side. So all that was still put in and held in the private side, we're going to put that into a new trust on the private side, and we're going to connect that with that new LLC on the public side with the interest that's going to be generated through the Treasury. And that interest is foreign source. And we're going to live off the interest for the rest of our lives and our inheritance. But if you fall into that trap from the DTC and grab those titles and start using them again, you just fell right back into the thing and you didn't get anything really. That's going to be the temptation. When somebody lays that $35 billion in your laps, what are you going to do with it? Are you going to merge the titles, or are you going to go out there and spend it? Then you'd have to go and set up your new accounts on the public side under this LLC, and then just write a check for it, just like you would normally, right out of your account, drawn against the interest.
Wouldn't it probably even be better if you set up a trust as well?
You could set a trust up off of the LLC and then put the interest in that also, yeah. That way the trust could be the agent for the trust.
Okay.
But the trick is you never want to use that agency, that LLC, or that trust for doing business.
Mm-hmm.
All you want to do is purchase goods and services for the consumption of the real man. So if you buy a piece of property, you can't ever sell it.
Makes sense.
You'd have to, wear it out and then just junk it, I guess. But I think we're being prescribed by prescription, which is since we've never made the claims, and since we've never made the claims, they're going to extinguish the claims and the rights that we've got. We have a limited amount of time to stop that. And how we're going to stop that is we're going to put an acknowledgement of the debt in. And under acknowledgement of the debt, under Black's Law, it says that stops prescription. That's the estoppel. And really what we're doing here is we're agreeing with them because we're acknowledging, yeah, we owe the debt. So now there really is no controversy. All right, you have to press star 6 to unmute yourself. So the acknowledgement is really the key. So we're going to put an acknowledgement of debt in also with an order for settlement simultaneously. So the acknowledgement of the debt will be the estoppel in an agreement that there's no controversy. And that'll probably time out, say, within 90 days on an international. So we'd have to put our paperwork together. And then we could make it so it's self-renewing, say, for another 30 days, let's put it that way. Or we could make it, say, for self-renews for 5 years. That should give us plenty of time to put the paperwork together. Call the Treasury Directive, do the DIB hearing, merge the titles, and everything I said before, or give the orders for the discharge and the set-offs, set up the new accounts, and then also asking questions as king. So it's as king, asking questions as king. So the king always asks questions. So the question I want to ask them is have I left anything out that will prevent you from doing what I ordered? Because if you say something that I left out, then I would give an instruction, then give me the form that I need. I ordered that you give me the form that I need to finish this up. So as long as I'm asking the question, I'm acting as the king. I'm as king. So when these people go in the DTC, and the DTC is asking them the questions, who's the king? So any questions so far?
I have a quick one, Christian.
Yeah, go ahead. Who's this?
This is Terry. With regard to doing trade or business with the U.S., and you were talking about property after we purchase it, couldn't we just donate it to someone or some entity?
That would be gifting, and gifting falls under Title 26 IRS Code Taxing.
I see. Okay, thank you.
If you gifted it into a private trust again, possibly. If I wanted to do business in the United States again, I have to form another trust or another corporation and do your business through that. And then whatever business you did in association with that corporation is taxable. Pay the tax then.
Okay, that's what I was going to get to next.
Yeah.
You answered it. Thank you.
But don't commingle with the new LLC and the new trust that you formed in there. Keep it totally separate. Don't cross it back in by doing any business. You just want to do a consumer. You want to be a consumer for the real man. Just purchase the products and service that the real man's going to consume. All right, thank you. I can buy some pretty nice cars and houses with that I could consume. If I want to give somebody something, that would be probably effectively connecting me back in with a business or trade. And I would be commingling, and then I would be ruining the trust.
Hey, Christian.
Yeah, Rhonda.
This acknowledgement of the debt and order for settlement and asking as king if we've left anything out, would that be done with our initial special deposit on the private side?
Special deposit on the private side for what?
Well, like our
deposit you're talking about?
The declaration, the expression of the declaration. Earlier we had talked about depositing that. Or are we not going to?
I see what you mean. Yeah, I think we're going to do that simultaneously, everything all at once. Because really, the acknowledgement of the debt and the order for the settlement, that's going to be our NOI. And in order for us to give that, we're going to have the SOI, which would be our claiming of that Declaration of Independence Trust.
Okay.
So as soon as we put that acknowledgement of debt in, that's going to put an estoppel and time out this prescription.
That ought to be the first thing we work on then, right?
Yes, right.
Before we lose it all.
So once we've got that acknowledgement in there and the offer for the settlement, now there's no controversy that we're in agreement with them, and then we can come back in, prove the standing, and then we can issue the orders and move the titles. Merge the accounts, terminate the straw man.
Okay, so the acknowledgement of the debt to be done first to create an estoppel until we get the rest of the paperwork done.
Correct, right.
Basically.
Acknowledgement of debt,
so that
settlement.
Would that go on the private side or both?
No, well, I'd actually be giving yeah, probably both sides, yeah. Mm-hmm.
Give everybody notice.
Yeah, give them notice, right. Because really it's the public side is trying to foreclose. Trying to foreclose by prescription. But if I do the acknowledgement of the debt, put in an order for settlement, prove my standing after I claim trust, prove the trust then I can do all this other stuff. I can do the public side order for the discharge, and I could do the private side order for the set-off. Then I could give the order to merge the titles, the orders to convert the debts to money, and close and settle the accounts. Then we'll have to have this LLC set up at least, and then I would do an order for setting up a new trust on the private side under a different name, say.
So this acknowledgement of the debt, that should really only be that should be a pretty simple...
Wouldn't be more than one page.
Yeah, just a one-pager. Hey, I acknowledge the debt. And
one page, the order of settlement, yeah. So anyway, I think we've opened up some new opportunities here just in the first 2 pages. We haven't got any further than one last week, but anyway. A little more clarification on that example. Any other questions? So, comments? Anybody at all? Last chance.
Well, how long do you think it'll get before we can start to write this acknowledgement of debt?
I think probably once we get the workshop started.
Because that would at least be good if we could, put an estoppel on them on taking everything till we get things cleared up.
Yeah, if I had more time, I'd work on it right now, but.
Well, thanks, Christian.
What's that?
Thank you.
Okay. Yeah, if anybody wanted to do some research into that acknowledgement of debt in Black's Law and see what it says back in some of the other, and say order of settlement, check on that and see what, and then look up prescribed and prescription also, because that ties in with it.
Christian, this is Doug.
Yeah, Doug.
What kind of ramifications will this have with the Federal Reserve and with the democracy? And I mean, do we realize what we're doing here?
I don't think a lot of us realize what we're doing. No.
Who wants to live in a democracy anyway?
I mean, if you do free the republic, where are the people that are going to take the offices?
That's true. Yeah. It would have to be a total reorganization. Yeah.
Isn't that already underway with a lot of the stuff that's going on behind the scenes right now with the Federal Reserve and the Treasury?
Probably, I'm probably not going to be able to stop it for everybody, but at least I might be able to stop it for myself.
Yeah, I got you.
I can't wake up everybody else, but those that are awake and those that want to do something about it, I think that's possible. I think we can save it for ourselves.
Yeah, I think if we have a small group, we can at least raise the awareness if we have the funds.
Well,
the private.
Yeah, funds we don't have on the public side, but yeah.
Yeah, on the private side we'll have plenty.
Yeah. after we get this all done, we may have all the funds we need then on the public side, but then by then it might be too late. So, but who knows? We'll go as fast as
we have time. Yeah, right.
Okay, anybody else? So, in closing, guys, has anybody Skyped in on this call and done it like they did on that other number? And do you know for a fact, are you being charged under Skype?
Well, Christian, I tried to get in on the number that you gave out today, the 213-289-0500, I think it was, and I wasn't. It wanted money from me. Now,
did you do it like
the other one?
Did you do it like the other
7? Yeah, it unlike the other call, the original call, the 712 number, the free conferencing was free for me with Skype, where the 7 number was not.
Same way you did on the other number? You did this number?
Okay, the 213-289-0500 cost money on Skype. Last week, 712-432, whatever, 0075, the free conferencing, was just that. It was free with Skype.
So is there anybody else who can confirm that also? Are they having problems they couldn't get in and it does charge on this number?
Well, I chatted with them and they said they could get on, but he was saying, well, what's a couple cents a minute or something?
Okay.
But I don't understand. What I don't get is there's no difference in sound quality, so why don't we just go with the one that we know is free?
Yeah, well, that's what I was know that we can get in on that other number. We'll still do the Share Plus meeting room on the computer, but then I'll switch all the calls to dropping all these other numbers with Share Plus today. Directly conference number. If everybody knows that works, then.
So I guess you just have to send out an email to the group and let them know what number it is that you prefer to use, I guess.
Right. Well, I'm just trying to work out all this thing because we're trying about 3-4 different setups here, and we're just kind of like eliminating the ones that don't work as great. So apparently it's going to be that free conferencing line, the 715 number, because that you get in with Skype up, it's free, and then we can do the Share Plus instead of the DimDim. We'll get rid of DimDim. We'll go Share Plus, and it'll be 2 separate systems then.
Right, the 712, whatever that was, the free conferencing is what you guys had me put into my Skype. I had to create a contact called free conferencing.
Right.
And when I did that,
243
I was able to
007.
Correct, 432-0075. And then I used the PIN number 917030, and I was able to get on that free conferencing call with Skype for free.
Okay, so that'll be the number we'll use on all the calls then from now on then.
Okay, and it looked like the guy Pete from England wasn't able to join us tonight from what it looked like from the chat because, he was like me, he didn't have money put into his account, so.
Right.
And he seemed quite knowledgeable and, really a nice guy. And he might be able to understand some of this English, old English words that we may not be able to.
Yeah, that's the problem. That's how they're getting us, with these outdated terms that they're still using.
Well, it's just, it's a complete foreign language, Let alone all the other trickery with the, whatever bastardized English, Black's Law Dictionary with different definitions. So it makes it quite the puzzle. I was going to ask you guys, have you heard of Benjamin Fulford by any chance?
If I have, no.
I think I'm going to send you, a link or something probably tomorrow to, maybe here this evening to, there's some stuff that's supposedly going on that the Chinese, the with the Japanese, the Black Dragon Society, and some other people, along with Interpol, is threatening to they know they've gotten that gold-plated tungsten bars, and that they believe that the Bush-Clinton crime family is the one that caused the earthquakes in Haiti, so they could run in there and grab the stuff out of the Haiti bank. So there's a bunch of stuff supposedly going on, that's pretty high intrigue with the money system, and the Federal Reserve, as we know it, may not be much after the 30th of this month, supposedly.
Well, now all that gold went into trust. It should be someplace, or at least still owe us. Let's put it that way.
Well, I don't know. By the time these guys, well, it may be, and I hope so, but I mean, supposedly, from what I've seen, oh my goodness, the theft. What's kind of interesting is that the Federal Reserve, they think that they've slaved the American people. Well, they've done dirty to everybody there is, the Chinese, the Japanese, everybody. So they're all pissed off, and, they want these guys, not to really exist anymore.
Either get legal standing and, we'll go from there. Now, legal standing might not stop a bullet, but at least I'm legal standing.
Well, once these guys take care of the Federal Reserve boys, which, because they've all gotten taken by them, then I actually think we're in a good position to restore our freedom, because they said they actually want to get rid of the Fed and put us back as a republic. So I think there's some stuff going on, if from what I read is correct, that really, like, people were upset that Obama had signed this executive order that basically, let Interpol into our country and to suspend habeas corpus, and that's because we got all these guys running around that are so, rotten and corrupt, and some of them are foreigners that we had to call in a, external police force.
Right, yeah.
To,
then again, who was the one that would allow all that to happen? Us.
Well, we the American people, I guess.
Yes, it was us.
Yeah. Yeah, but I also have to say is I believe I'm responsible for everything in my world, but I also have to believe that, by the time I was born in 1958 or whatever, that, I know by the time I was 21, friends of my father had written billions for the bankers' debts for the people, and, I got to the point where, I was, I had to just go hide and cool it, because I was going to be be thrown in prison, because, I was one of those patriot guys, and so I disappeared for a long time, and just completely got away from it and said, this ain't worth it. But by the time it's like, I don't know. Yeah, I can say I'm responsible, but by the time they dumb you down and convolute everything so bad, it's like, do you really have a prayer of figuring this stuff out?
Yeah, I think we do, and I think we are, and I think we have already. And now it's just a question of taking what we know and putting it into action and starting to take back what we've.
Well, I was going to say, I think, guys like yourself and, other people that, have gone to jail and really studied and figured this stuff out and knew that we were getting, that something wasn't right, and they paid with their life or their, paid for, just not necessarily in blood, but that and everything else. And then with the advent of the internet and everybody getting together, it looks like we are, closing the gap on them. But it's almost like now that we're closing the gap and about ready to figure it out, it looks like, they may not even be around to, I don't know, maybe exact our pound of flesh. And not that that's not necessarily what I want, but I just wonder really what will happen if
should make it a lot easier for us to clean it up.
Well, do you think these other people that, let's say the Fed gets dissolved and these other people that actually put, like gold into our economy, actually, the real thing, substance, what are they going to say that what we did? They're going to say, well, you were part of the problem because the Fed used you as collateral and, what real substance, David or Chris or, whoever, how much real substance did you put into the mint? They just use you for collateral and you were in some ways part of the problem.
Yeah, we were part of the problem because we didn't know or we didn't understand. But now that I do know and understand, now I don't want to be any more part of the problem.
Right, and I agree, and neither do I. But I mean, these other creditors that are standing in line for trillions of dollars, like China and Japan and other places, when we come up with our hand and say, "Well, I'm a lien holder," or whatever.
No, I'm not a lien.
I'm
not a lien holder.
I don't know if I got.
I have assets because their debts are drawn against my assets. Their fiction money has been created off my assets.
Okay, and really, so that's why I guess, I got it mixed up. So what were your assets?
Well, really, my signature.
Yeah, but they're going to say, okay, well, look, you can take a bunch of ink and write your name all over as many papers as you want, but I deposited gold, gold bars, and you wrote your signature, so,
Yeah, now where'd they get their gold bars? They got their gold bars from me. No gold came out of the ground unless a real man dug it out.
Well, that's true. And I also wonder why all of our gold mines and stuff are foreign owned. Anyway, that's another thing that's really irritating. But yeah, I guess. Well, you know more about this than I do, but it sounds like they're gonna, be honest with you, I'm kind of glad that from what I've been reading's happened because hey, if it takes some outside muscle to get rid of these guys, I'm all for it. And apparently,
valuation of the Pentagon, they switched it around. It went to down, say, 100 to 1. And it wouldn't make any difference to me because my assets are still held in trust, and what I have still should be there. If it's not, well, then we got to breach trust. We got another problem. But it should still be there.
Yeah, it doesn't matter. Like you said, if it, like I guess what your assemblers were saying, that it doesn't matter if gold's $1,000 an ounce or a penny an ounce. It doesn't really matter.
It doesn't make any.
Yeah, right. Right, because everybody's going to be working off the same scale. Hopefully there will be just weights and measures.
Let's just learn from our mistake that this debt fiat currency does not work unless you've got an equal set-off for the House Joint Resolution to bring the debt down on a manageable level. That's where the abuse came from. We couldn't balance the pressure. We mounted the,
they wouldn't let us.
Mounted the debt up.
They didn't give it. Well, from what I understand, they would even. Why didn't they? Why? It seems like they hid from us what really needed to be done to help them.
Well, I think it really came back with us because we didn't know what to tell them to do. What we did is we just elected somebody and sent them to Washington, D.C., and then 4 years later, we found out, they didn't do the job, so we just elected some more people and send them up there again, and they did the very same thing. I think that's the definition of a fool. When you want to change something, but yet you do the same thing that you did yesterday and you expect different results tomorrow by using the same method that you've done. That's a fool. Basically, we've all been fools.
Well, I agree, but when we're taught this is the system, well, they use the word democracy, which really it's a republic. But when they say that this is what happens, we have these fair elections, and then we find out they're not fair, they're not rigged, and there really is no difference between a Democrat and a Republican. And what we should have known all along is, like the original 13th Amendment that got swiped, or burnt during the War of 1812, was that we were never supposed to have these crooked lawyers in our country, let alone in positions of, be representatives of our government.
Well, we've been living on borrowed time all this time now, and it's time to pay the piper. We should admit our mistakes and start correcting the problems. But more people need to be getting awake. More people need to be what's going on. And maybe we may have to come down to a crisis to wake everybody else up. Because most everybody's still sleeping unless you're putting it in between a rock and a hard spot unless you've got some kind of problem. If you don't have any problem, I'll guarantee you will not get this stuff because you are not looking and you don't really care. So until the fire comes to your roof, you're not going to be able to call the fire department, even though the fire's at the door.
Yeah, that's how it always happens. Well, it's not me that's my ox and wagon's not in the ditch, so that's the other guy, so that doesn't affect me.
Right.
So that's
responsibility, and I'm not my brother's keeper. Well, I'm afraid my Bible tells me something different, so.
Well, that's all part of the problem of them, trying to taking Christianity out of the schools and giving this, just basically, I mean, they have subverted everything. They have twisted everything there is. I mean, it's like...
Yes, but I blame myself first, because I wasn't there to stop it. And I should have...
Well, me too. I didn't, I wish I would have had a different type of schooling and had different knowledge, but, eventually I found out about it, but then it's almost to the point where if you say something, then, I guess I wasn't ready to give my life for it, because that's what they wanted from a lot of people. I guess I was, plain and simple, I was scared.
Yeah, I don't want to cry over the spilt milk, let's get the paper towels, clean this mess up, and let's get on with life.
Yeah, I agree. I mean, and I think that's what this whole thing last year this time, or a little bit before this time, I mean, 2008, October, November, that was supposed to give everybody the wake-up call of what was going on. And then I think a lot of people understand, and they're pissed off, but I just don't think they really understand what's going on. I think there's a lot more millions of people that know that something is screwy, but they just, because of our education or lack of thereof, they just can't, they know something's wrong, but they can't figure it out.
Right, yeah.
Like that Matrix thing, that splinter in your mind. Something ain't right, but you just can't figure it out, so.
Mm-hmm. It is, yeah. But the truth will set you free.
Yes, sir, it will. Well, listen, I'll try to find that thing, and I think you'd probably be interested in reading it. And so I thank you for your willingness to help all of us, try to, come to grips with what's going on.
So keep on checking back with the movingtitles.com website for any new information that gets put up there, because I'm just about ready to start, putting some things up there that, like ISBN numbers for the books and some of the material that is going to be pertinent to what we're doing and things. So keep checking back with, and the website again is movingtitles.com. So just put that right in your browser and enter. That should take you right to the site.
Okay, I'll do that.
Put the call numbers up and the access PIN numbers. I'm going to put the books, the ISBN numbers, all pertinent information. So if you just check with the website, keep checking with the website. So next week we'll be using that other number instead of this one. So we'll just do away with that.
Can I ask a question?
Yes, who's this?
Hi, this is Lenore.
Hi, Lenore. Go ahead. Where are you from?
Minneapolis. I'm in Minneapolis right now. I was listening, and somebody asked a question that was such a brilliant question that I wanted to know since I started studying this in April. And right when you were going to answer it, I got cut off. So I dialed back in. It took me a while to get back on. I'm on Skype, but I pay Skype. I just use Skype for a phone all the time, so I don't have to pay anything no matter where I call. It's just $100 a year, so it's pretty cheap. But the question was, what is that asset? What is the asset? I don't understand what the asset is that we have.
Well, the asset that's held in private in 1933 was all the gold that was put into trust and all the interest that generated. That is part of the asset. But then the real asset is
so then when they go and they...
Well, let me finish. The real asset is not that tangible gold that you can put your hands on. The real asset is the intangible signature that you have the right to create as much credit as you want. It's a bill of exchange. No other entity has the right to make bills of attainders other than the real man and woman. Now, if that is properly managed right, according to House resolution, you could create as much debt that you want to get you through an emergency. And then once the emergency is gone, then you could relieve the debt by reducing the pressure by using the discharge and the set-off, which is the real way that the House Joint Resolution 192 was meant to function. It was meant to function and get you through an emergency. You had the ability to create as much money as you wanted in this system, to do anything that you wanted, and then get it back down to the more manageable levels. But see, we haven't done that. We've allowed the debt to compound upon debt, upon debt, upon debt, and finally the debt has become so burdensome that none of we the people can hold it up any longer. And that's what happens when it gets too far out of line. And they've used it to...
Well, you know, everyone that I have told and tried to talk to about this is so frightened out of their mind they don't even want to hear about it. So I just don't even talk about it anymore.
Yeah, you're more apt to tell people who are in a rock and a hard spot, somebody's got some problem, and somebody's going through a foreclosure or something. Those people are willing to listen because they're looking for an answer. Mm-hmm. Anybody else that doesn't have a problem, forget about it. You're talking to a wall.
Mm-hmm.
So be choosy to who you give your pearls to, because if you give them to swine, they're not going to appreciate it.
That's right. Well, thank you for your answer.
All right, so I think that's about it for tonight. So we'll see you next week, same time, but it'll be a different number.
Christian?
Okay, bye.
Yeah, go ahead. Who's this?
Is there a chance that we can get a recording of these phone calls sooner than later?
I'm going to be putting them on my website.
Okay. Hey, would it help you? I'm going to speak for Matt tonight. He's off the call now, but he'd be willing to help you moderate if that would help you out a little bit too, administratively.
Yeah, that'd be great. That'd be great. Yeah, maybe I get with Matt and talk to him then.
Yeah, good deal. Cool. Yeah, it'd be awesome to get these calls so we can go back and listen to them to be prepared for the next week. So.
Yeah. Well, we're just behind the technical. We're behind the technical wave. You know, we're behind the 8 ball, so to speak, until we get things up and running on the website, because I want to put everything up there, all the links to get all the downloads and everything. Yeah, everything is going to be accessible through that.
It's a lot of work anyway, so.
Yeah, so it's going to take me a little bit of time, yeah, unless somebody's got some skills and they can donate some time and help me out. So, but
well, I think we should figure that out so you can do the more important things. So.
Sometimes it's kind of a break.
Oh, I suppose you enjoy it, huh? Okay. I suppose it's like mowing the lawn. So.
Right. Yeah. All right, so.
Good deal. Have a good night. Appreciate it.
All right, thanks. See you next week or tomorrow night. Tomorrow night at, let's see, 10 o'clock.
Okay, very good.
All right.
Have a good one.
Which number?
The number? Yeah, that's the 715 number. Excuse me, 712. 712-432-0075.
Okay.
And the PIN to get in is the 917030.
Right, okay.
And that will be the number next week for this Monday call also.
Okay.
That'll be the actual number for all the calls, I guess, the Monday, Tuesday, and all the other calls I'll use. And then we'll use the whiteboard on Share Plus.
Okay.
All right. See you all tomorrow.
Okay, Lord willing.
Praise the Lord. Thanks.